May it please the court. My name is Emma Favela, along with my co-counsel, Angelina Hensley, and today we represent the respondent. In today's case, in favor of HB 1181 should be studied under rational basis review.
We will be giving a brief summary of argument using the following 2 points. 1, HB 1181 is not restricting protected speech, along with the second point being the appropriate standard of review for Texas HB 1181 is rational basis.
Moving on to our first point, HB 1181 is in no form restricting protected speech. HB 1181 requires age verifications to access obscene content and pornography, ultimately to restrict minors of such obscene content until they are of the appropriate age. The courts have continuously ruled that obscene content does not fall under protected speech and does not hold First Amendment protections, such as the Court of Ginsburg v. New York and Roth v. United States, as the courts held that obscenity is not within the area of protected speech.
Furthermore, past precedent has allowed the government to regulate obscene speech and content in public places, as seen from Paris Adult Theater v. Sladen, as the court ruled that the government could regulate the exhibition of obscene material in public places. The court further addressed how the First Amendment does protect free speech. However, that protection does not extend to obscene content, particularly in public areas where it might be exposed to unwilling audiences. Additionally, the Court of Roth v. United States further held that obscenity is not protected expression and may be suppressed without a showing of the circumstances which lie behind the phrase clear and present danger and its application to protected speech.
To address the second point, the appropriate standard of review for HB 1181 is rational basis. As seen from the Court of Ginsburg v. New York, the court's central holding that the regulation of distribution to minors of speech obscene for minors is subject only to rational basis review. Rational basis review is the lowest standard of review which determines whether there is a legitimate government interest in an ordinance or statute, in which our case today is HB 1181.
In our case, the government has a legitimate interest to protect minors, as seen from Prince v. Massachusetts, as it states that the state's authority over children's activities is broader than over actions from adults. The appropriate standard of review for Texas HB 1181 is rational basis, as the government is in no way infringing upon protected rights, as petitioner may try to contend that pornography is a form of protection, expression, and speech. That is simply not true because of obscenity ruling.
Furthermore, in Miller v. California, the court used a 3-pronged test to identify obscene content, and if it was found to be obscene, then the court may regulate it. Under this test, pornography from an average man would appeal to prudent test that is sexual, and as a whole does lack serious literacy, meaning that even though our bill isn't targeting the content of pornography and focusing on the children's well-being, pornography cannot also be considered protected speech, meaning no sense of First Amendment protections are being violated, which is why rational basis should be chosen since it would fit in our case today.
The court is now open to questions.
What, if any, is the value of low-level speech such as pornography?
Your Honor, pornography is a low level of speech and doesn't fall under protected speech as seen from the cases such as Ginsburg v. New York and Miller v. California. Although the speech itself is not protected because of its obscenity, as seen from Roth v. United States, as it states that obscene material is not protected by the First Amendment, nonetheless, it still holds personal value to content creators, as pornography is a form of expression, just not protected expression.
Was the First Amendment created to protect this kind of speech? Does that matter here?
The First Amendment was originally created to essentially give the freedom of speech expression, assembly, religion, and so ultimately the freedom to speak out against the government. However, over time, the First Amendment has protected multiple different types of forms of speech and expression. Although the wide variety of protected speech that fall under the First Amendment protection, pornography does not fall under the protected blanket, as multiple Supreme Courts have ruled that obscenity is not protected, especially in the case of Miller v. California, where the court ruled that obscene material, if outside of the First Amendment protection, also seen in Roth v. United States, as the court ruled that obscene material is not protected by First Amendment and could be regulated by the government.
Whose First Amendment rights are impacted by the Texas law? Is it minors, adults, or the platforms themselves?
In our case today, minors viewing or seeking pornographic items are affected, but their First Amendment rights are not affected. It should be restated that obscenity is not within the area of protected speech or press, as seen from off the United States. Pornography is an obscene form of expression and not protected speech. Although adults are affected as well because of the age verification on pornographic websites, there is a need of burdensome to be met when it comes to the state's interest in protecting minors, seen in Prince v. Massachusetts, as the court recognized that the state has an interest to protect the welfare of children and to see that they are the safeguard from abuses, which might prevent their growth into free and independent, well-developed men. In our case, the Texas law was made in the state's best interest in regards of protecting minors from pornographic materials until they are of the reasonable age to view it. Furthermore, in the court of Ginsburg v. New York, the ruling in that case solidified that the principle that the government could impose stricter restrictions on what minors can access compared to adults, particularly in areas of obscenity. It is not a limit of adults' rights, more so simply that it's just a burden on commercial distribution such as pornography.
Why can or can't the government simply ban access to pornography online?
The government can't simply ban pornography, as the courts have already stated. The obscene material is not under the First Amendment protection. Additionally, the state has continually stated the government can regulate obscene material. As seen in Paris Adult Theater v. Sladen, the court ruled that the government could regulate the exhibition of obscene material in public places. The court addressed that the First Amendment protects the freedom of expression. However, it does not include obscene expression, especially when it's in public where there may be unwilling audiences that may be exposed to such obscene content. Respondents can apply this rule as pornography is on a public platform such as X, formerly known as Twitter, Instagram, Google, and YouTube. These platforms are easily accessible to minors. The state has the government compelling interest to protect minors. To achieve the goal, the government is allowed to ban porn to minors.
In what ways is the Texas law a content-based imposition on speech? In what ways is it not?
The Texas law, in our case, is a content-neutral law, by which is why it should be under the rational basis standard, as said in the case of Ward v. Rock. Against racism, content-neutral time, place, and manner regulations are permissible, so as long as they are narrowly tailored to serve substantial government interest and do not unreasonably limit alternative avenues of expression. The court added that the method and extent of such regulations must be reasonable. That is, that it must be the least intrusive upon the freedom of expression as it is reasonably necessary to achieve a legitimate purpose of the regulations, as seen from United States v. O'Brien. Furthermore, in our case today, the Texas law is tailored to serve a substantial state interest and has the means of regulations that are designed to address a specific problem that is not overly broad or vague. This problem and the state interest being access to pornography to children. The age verification requirement in our law is the purpose of the law is no way based on the content of pornography, but rather on preventing access by minors and protecting their welfare. This aligns with the principles in Renton v. Playtime Theaters, where the court upheld that zoning audiences for adult theaters, finding the audiences were content neutral because their purpose was to address secondary effects rather than suppressing content, which is alike to our case today. The law does not prohibit the creation or distribution or viewing of pornography for adults. It simply regulates the access based on age. As said in Renton v. Playtime Theaters, it states that restrictions of this kind are valid and provided that they are narrowly tailored to serve a significant governmental interest, and they leave an open example and alternative channels for communication of the information, as seen from Clark v. Community for Creative and Nonviolence.
Is including social media and search engines under the age verification requirement a reason to find this law unconstitutional?
No. HB 1181 requires age verification on websites with pornographic material, but not on search engines or social media that don't have more than 1/3 or more of pornographic material. The law is narrowly tailored to target specific pornographic websites while leaving search engines and social media platforms untouched. This distinction ensures that it does not restrict free speech or burden adults seeking non-obscene content. In Ginsburg v. New York, the court upheld laws restricting minors' access to obscene material, recognizing the government's interest in protecting children from harmful content. content. Similarly, in Ashcroft v. Free Speech Coalition and United States v. Playboy Entertainment Group, the court affirmed that protecting minors from adult material is a compelling government interest, as long as it does not overly restrict adult speech. By focusing solely on websites with explicit material and requiring age verification only on those sites, the law limits its impact, balancing the protection of minors with adults' rights to access lawful content. This narrow approach is constitutional.
The law requires age verification when more than a third of the website's content is inappropriate for children. Would the law be more or less burdensome if the threshold was increased?
The law would be less burdensome. If the threshold was increased for this law, this would remove the chilling effect on adults believing that there are mere search engines or numerous other websites that could be affected.
Ashcroft v. ACLU applied strict scrutiny to a law that burdened adults' access to online speech, not the rational basis test. Why should the court not apply the same standard here?
The court should not apply strict scrutiny to our law today because our law is made for a state interest, which fits the requirements for rational basis. Although there is some burdensome to adults, First Amendment protections are not being validated that would ignite the need for strict scrutiny. It is well settled in Ginsburg v. New York that a state or government can adopt more stringent controls or communicative materials available to youth than on those available to adults, meaning that adding restrictions to pornographic websites is specifically said in Ward v. Rock against racism. Content-neutral place and manner regulations are permissible as long as they are narrowly tailored to serve a substantial government interest and do not unreasonably limit alternative avenues of expression. The difference between our law today and the application of strict scrutiny in Ashcroft is that the Supreme Court applied strict scrutiny because the case involved a content-based regulation of speech protected under the First Amendment. The court in Ashcroft recognized that speech is protected as long as it is not obscene under the Miller v. California test. However, there needs to be a clear establishment that pornography is not considered to be protected under the First Amendment. Ginsburg v. New York establishes that obscenity is not within the area of protected speech or press cited in Roth v. United States. The Miller test further applies a three-pronged test, evaluating that what is considered to be obscenity. This test being whether the average person applying contemporary community standards would find that the work taken as a whole appeals to prurient interest, B, whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law, and C, whether the work taken as a whole lacks serious literacy, artistic, political, or scientific value. Under this test, pornography from an average man would appeal to prurient interest because it is sexual, and as a whole would lack serious literacy meaning. Even though our bill isn't targeting the content of pornography and focusing on children's well-being, pornography simply just cannot be considered protected speech, meaning no sense of the First Amendment protections are being violated, which is why rational basis should be chosen since it's what fits our law today because of state interests being the main concern.
Ashcroft identified that content moderation through filtering settings was a less restrictive means of protecting minors online. Has that proven true in the time since Ashcroft?
Yes, filtering does hold less restrictive means of protecting minors online. However, in numerous different cases, the mere filtration was not quite as sufficient as to the age verification that our bill purposes to suffice as the welfare of minors. An example of one of these cases would be in the case of United States v. American Library Association, where the court upheld that Children's Internet Protection Act, CIPA, which required children libraries to use internet filters to protect minors from harmful content. The case highlighted the limitations and challenges of these filters, as libraries had to disable them upon request of adults. In our case, however, because of the age verification, where adults would be able to easily access pornographic websites by a mere online verification, where the burden of asking permission compared to the case of United States v. American Library Association would be less burdensome, and the age verification would also be a way of demands where it also is less restrictive and more efficient.
If the court were to find that the Texas law burdens the First Amendment rights of adults, does that mean petitioners win?
In our case today, the adults' First Amendment rights are not burdened since pornography does not fall under protected speech. As said in Ginsburg v. New York, obscenity is not protected expression and may be suppressed without a showing of the circumstances which lie behind the phrase clear and present danger in its application to protected speech. Roth v. United States, however, it should be noted that HB is somewhat burdensome, but not to the point where it burdens First Amendment rights. The Texas law imposes only an incidental burden on adults. Adults are not prohibited from accessing pornographic material, they are simply required to verify their age. This is a procedural safeguard, not a content restriction. Similarly, mechanisms like identification requirements for alcohol or tobacco purchases have been upheld under rational basis because they serve important government interest while imposing minor burdens on lawful users. Ward v. Rock against racism comments on these types of regulations used in our law today, and in United States Library Association, commenting that the method and extent of such regulation must be reasonable, that it must be least intrusive upon the freedom of expression, as in reasonably necessary to achieve a legitimate purpose of the regulation. In our case today, these age verifications are the least restrictive means seeking out welfare for children while still allowing accessibility to pornography to adults. Although somewhat burdensome, but as said, this burdensome would not mean petitioner wins.
Adults concerned for their privacy may not access websites requiring age verification. Is that a sufficient reason for striking this law down?
No. While privacy concerns can be argued to create some sort of chilling effect among adults seeking non-pornographic material, this argument would only carry weight if the chilling effect were to serve enough to render the law overly broad or not narrowly tailored. In our case today, our law is narrowly tailored to simply fulfill the requirement of the welfare of protecting minors from harmful materials which would be deemed as a compelling interest, as recognized in the cases of Ginsburg v. New York and New York v. Ferber. Our law is not overly broad, since the law applies specifically to just the websites that are the ones most targeted risk, such as pornographic websites, as stated in the bill, and websites that carry more than a third of pornographic material. Not all online platforms or unrelated speech. Unrelated websites and platforms is not what the bill is targeting, since our bill is not targeting specifically content. Furthermore, while it could be seen that this law could impose some sort of privacy, this privacy cannot be sufficient enough to completely strike the law out. The age verification method is the less burdensome way and less restrictive way to fulfill the bill's compelling state interest. Filtering tools, parental controls, or voluntary compliance programs have proven insufficient in cases such as seen as Ashcroft v. Free Speech Coalition, where certain alternatives were deemed unworkable in protecting children from child pornography.
If the court finds that the law requires examination under strict scrutiny, does that mean that the petitioners win?
Yes, if the court were to find that HB 1181 requires an examination under strict scrutiny, the petitioner would win. However, that is not the case as strict scrutiny requires such a high bar in which HB 1181 does not fall under. Additionally, it would require for the courts to rule that obscenity is protected by the First Amendment, which would be ruling against past court rulings. As President has stated, obscene material and expression is not considered speech and doesn't fall under the First Amendment protection, and which strict scrutiny itself deals with the fundamental protected rights, which pornography is not within.
Are the privacy concerns presented by online age verification similar to the privacy concerns required to access age-restricted purchases in a traditional brick-and-mortar store?
Yes, both online age verification and traditional motor stores both aim to prevent minors from accessing age-restricted content or products, whether online or in person. For example, before purchasing alcohol, the cashier must check the buyer's ID to make sure they are 21 or over in order to purchase the bottle. The age verification bill will be doing such a similar thing and just making sure that to restrict such pornographic material until the minors have reached a certain age.
In the years since Ginsburg v. New York, have increased technology capacities increased or decreased the privacy concerns associated with age verification processes?
Since the ruling of Ginsburg v. New York in 1968, there have been many technological advances to better our society. Some of those specifically are tied to age verifications. For example, age verification will censor certain information from being exposed to content that may not be appropriate for younger ages. Additionally, there are some user age verifications now that only require your date of birth without exposing personal information and data. Furthermore, due to the advances, there have been newer and better ways that some platforms have found to protect and keep personal user information stored.
Online access to harmful materials presents unique obstacles to parents trying to protect their kids. If this law is found to be unconstitutional, what else can Texas do to protect minors accessing online material?
If the court were to find Texas House Bill 1181 unconstitutional, the court may look into other options that limit the obscene content being distributed to minors, such as parental control tools that allow parents to look and regulate what their children is accessing and or on the internet. Additionally, online platforms would have to become more strict on enforcing their rules in preventing minors from accessing obscene content. There could also be a harsher consequences to the rules on the restrictions.